All right. Welcome to this week's OK at Work with myself, Sarah Sawyer, and my colleague, Russell Berger, attorneys with Offit Kurman. And today we are talking about the Americans with Disabilities Act, the ADA, and the interactive process and how that interacts with medical marijuana usage. More and more states are having medical marijuana, some are having recreational marijuana laws. So it's something that I've definitely seen come up with my clients more and more every year. So what do people need to know about the ADA and the interactive process, Russell?
Yeah, to kind of give it a high level background, so the ADA is the law that protects employees with disabilities or regarded as having a disability and requires that employers engage in an interactive process when an employee comes forward with a request for an accommodation in order to determine if there can be a reasonable accommodation and to go back and forth with the employee to try to figure out what works from the business side as well as from the employee with the disabilities side. And basically, the first level of this is if an employee comes forward and says, I have a disability or I'm regarded as having a disability and I need an accommodation, then that triggers the employer's obligation to engage in the interactive process. Similarly, if the employee doesn't necessarily come forward in just as specific manner, that obligation may still be triggered because when the law looks at it, it's going to put more emphasis on the employer to get it right than the employee to use certain magic words to make the request. So once a request is made, then the employer is supposed to engage in an interactive process where they go back and forth and try to figure out what possible solutions could exist. Now, sometimes this is a pretty straightforward process. The employee comes forward, I have a disability, I have a bad back. My reasonable accommodation is that I request a standing desk, and the employer, receives that request, can seek medical information if they like, and can go back and forth with the employee about whether it's the actual right solution to the employee's problem, whether it fits within the business model. Spending a few $100 for a standing desk with someone who's got a legitimate, bad back medical issue is going to be a reasonable accommodation. They buy on the desk, problem solved. Where we see a lot of, where Sarah and I think get a lot of calls on this is when it comes to mental health. That's a lot harder to pin down than an orthopedic injury, for example. And there's a lot more gray area when it's coming from a diagnosis standpoint, from a treatment standpoint, from a how do we make this work in the workplace standpoint. But the law still remains the same. You're supposed to, engage in that back and forth with employees who come forward with those kinds of reasonable accommodation requests and work through that process to see what can be done within the parameters of without causing an undue hardship, which is the legal term of art that exempts an employer from having to make an accommodation.
Yeah, and where I get a lot of questions, on the medical cannabis side is that, when an employer hears medical, they go into the ADA bucket as they should, right? So, all right, this person needs this for their medical need, their mental health, their physical ailment, whatever it may be. They've got a medical marijuana card. What do I do with that? Do I need to give them an accommodation? Do I need to go through that process? We normally don't allow, the use of marijuana. If someone tests positive, then it's a positive test, and we have a whole set of rules for that, right? So I'll get a lot of questions about whether that's covered, whether they need to do anything there. And the answer, as I always say on here, as lawyers, we always say it depends, but at least at the federal level, under the ADA, there is no right to an accommodation for medical marijuana usage. It is, marijuana is still federally illegal. There's been a lot of federal courts that have ruled saying that there is no requirement for employers at that federal level under the ADA. The EEOC has issued guidance on that as well. However, a lot of states, not a lot of, but a fair amount of states have medical marijuana required accommodation laws. So a couple would be Nevada. There's also in a couple states, there's medical cannabis anti-discrimination employee protection. So not terminating an employee just because of their medical cannabis usage. So Delaware is one of those, District of Columbia, Maine, Minnesota. So there's a couple of states where this analysis is a little bit more complicated. Here where we sit in Maryland, we don't have any special laws right now as it relates to medical cannabis accommodations or anti-discrimination provisions, but that could change. So that's another thing about this area as well, is that it's definitely, the laws are changing as it relates to medical cannabis and recreational. So whenever we talk about cannabis on OK at Work, we always say stay tuned, because it's definitely changing, and more states might follow suit with some of these other states that have these laws.
Yeah, and one other point I want to make, whether it's medical cannabis as an accommodation in certain states or any other type of accommodation, as an employer, you're always allowed to manage performance. And there may be sticky issues in terms of timing, and there's a lot of nuance and finesse to these issues at times. But from an employer standpoint, the basic advice that I always give is don't manage the disability, accommodate the disability, manage the performance. And if someone has a disability and they have an accommodation, you accommodate that, but you don't. It doesn't mean that you exempt the employee from performing their job the way they're supposed to perform the job. So in the medical cannabis context, even in a state that has protections for that, it doesn't mean you can come to work stoned and not able to perform. Like, you still got to be able to do your job and do your job safely. So, and that would, to take it a step further, there's other regulations, like, for example, if you're working on vehicles, if you're a driver, DOT regulations are going to apply and make that this whole analysis, one level even more complicated. But at a high level, I think the simple thing is, for employers to know, is that when someone comes forward requesting an accommodation, you got to engage in the interactive process. You got to work through it with the employee, and ultimately, if you want to manage the performance, you don't want to manage the disability or the accommodation.
Yeah, and always important to be thorough here. So I'm always happy to, when I get calls from employers saying, like, I think this might be in the ADA realm, I think this might be something I need to do here. And I'd rather get that call and people exercise caution as it relates to these topics. Because as you said, Russell, it's, there's a lot of onus on the employer to get it right. And so if it's even just starting to wade into that category, it's worth the call. It's worth looking into it, working with the employee on it, because the consequences of not doing so can be severe. So if your spidey senses are tingling and you think it might be crossing into something you need to comply with, then definitely trust that instinct and get to the bottom of it for sure.
Absolutely.
Well, thanks, Russell. We'll see you next time.
Thanks, Sarah.